Hi, it's Bill. I practice divorce law at the Gentry Law Firm in Marietta, Georgia. This is another in our series of Lunch and Learn webinars about divorce law and how different aspects of our lives are changing because of coronavirus and social distancing. We expect today's program to run about 15 minutes. Afterwards, we'll be posting it on our YouTube channel, Gentry Law Firm LLC. At the end of the presentation, we'll take some questions that you can post in the chat box. Today, we're going to speak with my good friend Linwood Gunn. Linwood has been practicing law since 1992, and he handles a lot of employment discrimination cases. Welcome, Linwood.
Thanks, Bill. I appreciate you having me.
Good. Well, Linwood, tell our viewers a little bit more about you and your practice.
Okay. Yeah, as you said, I've been practicing since '92. I've worked at some mid-sized firm and a smaller firm, and in January this year, right before coronavirus, I decided to open my own shop here in Marietta. I grew up mainly in Cobb County and live in West Cobb with my wife and my 2 children.
Now, where's your office located?
In a great neighborhood right next to you, right off the square, 244 Roswell Street.
And we're at 254 Roswell Street. We just coincidentally moved 20 feet from one another earlier this year.
Yeah.
Well, Linwood, in the days before COVID, what kind of issues did you and your clients typically discuss with regard to employment discrimination issues?
Well, when I first started practicing, I did just a wide variety of areas of law, not just employment. And over time, I've gradually focused more and more. And right now, my practice is probably 75% employment law. So it runs a gamut from counseling employers about day-to-day human resources and employment issues. How do you discipline someone? Should I fire this person? If I do, how should I do that? But more counseling individuals, the employee side these days. Discrimination, takes all forms. I've handled cases based on race, national origin, religion, a lot of disability issues, and a lot of sexual harassment, which is kind of surprising. So a lot about non-competes, different kinds of employment agreements as well, and then issues. And sometimes I'll talk to an employee when they're starting to have problems on the job and they're trying to decide, should I come up with an exit strategy before my employer finds a way to fire me? And sometimes it's after the termination or even after they file a lawsuit when I first start talking to them.
So you're not just looking to fix the problem once it's done. You're counseling either the employee or the employer before things get to a head.
Yeah, and that's right, and that's ideal. Sometimes they're either the employee or the employer, if they have a strategy before they go down to that final decision, do I fire this person, or the employee decides, should I resign at this point, or should I file a complaint of sexual harassment? I think it's a lot. Sometimes you can resolve it early on, and it's also, which is to everyone's benefit, obviously. And if you don't resolve it, at least you've got an established strategy going forward, which is very helpful, I think.
So obviously you don't represent an employee and an employer in the same situation, but you represent them in one or the other in various situations that may arise.
That's correct.
So and I know we didn't talk about this while we were getting ready, and I hate to spring a question on you, but yesterday there was a big opinion out of the United States Supreme Court that impacts employees and employers. Can you talk a little bit about that?
Yeah, actually, it's the Bostock case, and that actually it was Bostock versus Clayton County, Georgia, and there were 3 different plaintiffs, and the Supreme Court is actually trying to resolve a dispute between the 11th Circuit, which that's where we are. The 11th Circuit Court of Appeals is a very conservative pro-employer circuit, and all the courts in Florida, Alabama, and Georgia have to follow their guidance. The 11th Circuit had found that there was no protection for this individual because he was gay, and they said that's not sex discrimination. It's discrimination based on something else, and it doesn't fall under Title VII. There were two other plaintiffs. One was transgender, and the other one, I think, was gay as well. And the interesting thing, I sort of thought that was an easy call for the court, and I haven't really studied the opinion yet, but apparently there's some really very pro-employee language in there about just how you interpret Title VII, not just for purposes of those issues, but for purposes of all these other categories: race, gender, national origin, and so forth. So a lot of people were really excited about it. And it's interesting because I was thinking, you had that case yesterday in the middle of this huge social unrest involving race, and as imminent and important as COVID is, I think those two facts, the racial issues and this case going forward, may impact employment law more than some of these COVID issues that we're dealing with right now.
Wow. So this, you said Bostock case really could impact employment discrimination far beyond just gay and transgender issues.
Oh, absolutely. Yeah.
Okay. Well, so let's talk a little bit about COVID. So are you seeing some new and different types of problems arising now that COVID has so heavily impacted the economy? I know there's been some federal legislation and so forth. Can you talk to us about that a little bit, kind of illuminate us on it?
Okay. Yeah. And I made a list because there's so much here. They extended a lot of the unemployment benefits. I was looking at doing some research earlier. They've paid out almost a total of $3 billion in Georgia just since the pandemic hit. But you've got all these unemployment protections which are enhanced. The thing I think some people don't know is there's actually a new category that was enacted that allows people that would otherwise not be eligible for unemployment to get unemployment. People that are self-employed, independent contractors, typically would not be eligible for unemployment at all. And in those instances, what they need to do is apply under the state framework in Georgia, and then once they're rejected, then they can apply for the federal benefits, which is, it's over $900 a week. It's very substantial. You've got all these unemployment protections. You've got the issues with the paid leave, which is an overlay on the Family Medical and Leave Act, which is typically unpaid, but now there's pay, and it's extended the time for that. And one of the things that I think is going to be a coming problem with that is that people, even now, when they expanded the leave requirements, you typically had to have a serious medical condition, or you could have time off for adoption or birth of a child, for caring for someone with a serious medical condition. But because they've overlaid this coronavirus, which is impacting everyone, it's a much broader group of people that are impacted by this new FMLA that they've enacted. And I think a lot of employers aren't aware that once that the retaliation aspects of FMLA then apply to a wide variety of people. And there's already been cases filed. There's one case in Pennsylvania where someone said, I was fired because I tried to get my leave entitlements, and the company fired me. So the things like job restoration, which you would have under the FMLA, typically if you take FMLA leave, you're entitled to be reinstated in same or similar position at the same pay. Those things all apply now to a huge group of folks. So I think that's kind of a trap for some employers. And there's a lot to become educated on in a very short period of time.
Now, are a lot of these protections that were in the recent federal legislation require a threshold minimum number of employees? I know a lot of the previous anti-discrimination laws did. Can you talk a little bit about that for those who may be employers who are watching.
Yeah, it's strange and it's very complicated, and you wonder how they arrived at some of these figures, but it doesn't apply. The FFCRA doesn't apply to employers with more than 500 employees. And generally, the way they look at the number of employees, which is important for a small employer especially, is they're looking at people on payroll. So if they're temporary, if they're on your payroll, if they're part-time, they count. So they have some exemptions for employers that have less than 50 employees, and they have some other differences. If you have less than 25 employees, you're not required to reinstate the employee to a same or similar position. Other than that, it applies generally to even small employers, which the regular FMLA, you had to have 50 employees.
Okay.
So it's a morass. It's there's different rules for different categories depending on the size of the employer.
Okay. Well, are there any other kind of overarching thoughts that you might want to give to employers or employees in some of these employment discrimination issues that you're seeing more recently with COVID?
Yeah. What I've seen, that a lot of issues, a lot of people are genuinely concerned about going back to work because they've been teleworking or they've been laid off, and they're concerned about their safety. And as the government has gradually eased up on the restrictions, a lot more people are starting to open up shop. There are some things to think about, and generally what the OSHA requires that they comply with the CDC guidance, and things like social distancing are reasonable to expect. So if they're concerned, and particularly if they're in one of those vulnerable categories, people that have a compromised immune system or people that are a little bit older, they can contact OSHA, they can talk to their employer about that, and they shouldn't be fired because they take that tack. Employers need to just be educated about all of these things, and in particular about the leave entitlements, so that they can not retaliate unknowingly against someone for trying to exercise their rights, I think.
Okay. Well, and of course you raised a really good issue. Now, like half of my employees are working remotely now, and of course, and I think you had mentioned before we started the call that you're often working from your home and remote locations. If an employer wants to get more information about the best way to set up a reopening plan, do you have any thoughts? I mean, is it going to the CDC website, or to be COVID aware, I guess?
Yeah, there's a lot of good resources out there. There's the CDC website is one. If you go on the Department of Labor, the www.dol.gov, that has a lot of resources and links to the CDC and other. The OSHA guidance is very helpful, and they've got a specific guidance on there about reopening.
Okay, no, that sounds very helpful. Well, we're getting close to the end of our time. Do you have any kind of closing comments that you'd like to make to our viewers about this?
It's an interesting time, and I think that it's going to change the landscape, like we were discussing before. A lot more people are going to be working remotely, I think, in the future, and I think people are going to look at workplaces a little bit differently. And I think it's interesting because it's kind of, to me, it's shown how much we all really need the social interaction when you're deprived of it. It's something you really crave. My 17-year-old son is feeling that acutely right now.
Oh, my goodness. Well, I know there are a lot of kids out there graduating from high school or college or graduate school and not having any ceremonies. And of course, nobody knows when and how school will start in the fall. So it's kind of a chaotic, crazy situation.
Yeah, and it's sad for all of them. It's too bad that they don't get the celebration that they all deserve.
Well, so if folks want to follow up, employees or employers, Linwood, how would they contact you?
My website's the easy way. It's got all my contact information. It's www.atldiscriminationlawyers.com, and that's plural. Or you can just Google me and find that. I'll be happy to help.
Wonderful. Well, you can reach us at the Gentry Law Firm at 770-425-5573, by email at info@gentrylawfirm.law, or through our website at gentrylawfirmgeorgia.com. Please like and follow our firm on Facebook, Twitter, Instagram, YouTube, and LinkedIn for more updates. And please share this video with anyone who may need it. I haven't seen any questions pop up in the chat box. So at this point, I'm going to just say thank you again for employment discrimination lawyer Linwood Gunn for joining us. We're signing off. Have a great day.
Thanks, Bill. Thank you.